We are live.
Welcome to the House Judiciary Committee this Friday morning, April 17th. We hadn't planned on meeting today, but we have a proposal of amendment to H626 is on the notice calendar, so it will be on the floor on Tuesday morning. And it was either today or coming in early Tuesday morning. I don't know how much we love not coming in early on Tuesday morning. So we're going to take a look at it.
I don't mind.
It's very. Oh, we can do both. Oh,
No.
I can start scheduling other work for Tuesday morning. Since it's okay. No. So this is again draft number 1.1 of H626. It's in the calendar as well, and I will have turn it over to Michelle to explain what this amendment does, and then we can hear from Kim. And I don't, depending on how long this all takes, Charlie Glisserman's not available until 11. And I haven't heard, I mean, I've been in contact with Matt Valerio, and I don't know if he wants to, wait a second. Well, I will read his email after you explain the amendment.
Good morning. For the record, Michelle Childs, Office of Legislative Counsel, and you should have, I think, did Nate give you the copy of?
Yeah.
So
Yeah.
great. Okay, so we're working off the same document. I can also just say is that this language I drafted. So one of the senators asked a question about, because you have in your section 2 relating to dissemination of sexually explicit images without consent, you had a differential penalty for if the victim, or maybe it was sextortion, you had a differential penalty if you had a minor victim. And so one of the senators had asked about that in the context of voyeurism, because they had one of the survivors of the Kilburn case, remember that we talked about, testify and talking about the 16-17 issue and how it's not captured by the child sexual exploitation laws in Chapter 64 of Title 13. And so Charlie, on behalf of the network, in talking with Dominica at the AGO, this was their recommendation of kind of how to address that situation. And so what you have here in the amendment that the Senate did is that in Section 1 on the voyeurism crime, it created a higher penalty if someone engages in either viewing, photographing, filming, recording in any way someone who is under 18 years of age. So if you look at the language there, subsection J on the penalties, so it just creates it. So you've got subdivision 1 is for anyone who's 18 years or older. Yep. And then subdivision 2 is the same structure for it, but has it if the victim is under 18 years of age. So you'll see that for if the victim is an adult, it doesn't change any of the penalties there. So it's a 2-year misdemeanor. But if it's a minor, it would be a 3-year felony. And then for second offense, up above in subdivision 1, it is a 3-year felony. But if the victim is a minor, it's a 5-year felony. That's it.
What would happen, like 2 17-year-olds, one filming the other, but it was consensual? Does this like?
No, because remember, voyeurism does not involve any consenting to the filming, right? If there is consent to the filming and then someone distributes without consent, that falls under the dissemination of sexually explicit materials without consent statute, which is separate from the voyeurism. Voyeurism, there's never any consent.
Any other questions for Michelle? Nope. All right, next meeting, we'll hear from Kim next.
Good morning.
Good morning, Kim.
Kim McManus, Department of State's Attorneys and Sheriffs. This amendment in the Senate occurred after the department testified. I listened to it. I heard the recommendation for the group considering it. And, you know, we don't, this is a decision for you all. If you want to have the penalty for victims under to be higher, we don't have an issue as far as, yeah, no strong feelings. I think either way, I think generally speaking, we do appreciate that when our victims are younger, that's higher penalty is appropriate. There was a discussion on the Senate side, briefly contemplating sort of what if both actors are under 18. And as Ledge Counsel said, the issue is consent. But just for everyone to realize, if the bad actor, so to speak, is under 18 and the victim is under 18, this would be charged accordingly. It would be, you know, within the delinquency statute, but it would be, you know, charged with that. And there was sort of a statement of like, well, it's okay. It's going to be handled in juvenile court. And that's accurate, but I do just want to caution, you know, you wouldn't want to just quickly fly by those scenarios. So just raise to the committee, and I do not have a position either way, but just to take your time just to think through whether you have any concerns about, you know, both the defendant and the potential delinquent and a victim both being under 18. Again, no position. We fully appreciate why this was presented, and it does balance out with the disclosure statute that you created 2 tiers of penalties there based on being under 18. So we appreciate that, but we did just want to raise, you know, on the delinquency side, those would be 2 different ways that we would petition.
So this doesn't affect existing law then as far as to people under 18?
No, correct. Yes.
Questions for Kim? So, thank you, and I've waiting to hear back from Matt Valerio on whether he wants to jump on Zoom, which I've sent him the link, or if he just wants me to, or if he just wants to rely on his email that he sent me. Also, I just sent an email to everybody with written testimony from the network because they're not available until 11, and I don't know if we're gonna. I guess the question is, do we have questions for them beyond what's in their written testimony? If and I could just read it just for so.
Did you say you sent us to the?
I sent it to Judiciary. I haven't sent that. I wanted to get from him that he was okay with me to send it forward. I mean, I don't think it's any problem, but I just waited to hear from him. He's been getting back to me quickly, but the network submitted this morning the written testimony. It says, "Thank you for the opportunity to testify on the Senate amendment to H626. The Vermont network supports H626 as passed by the Senate. The Senate amendment creates an enhanced penalty for voyeurism perpetrated against victims under the age of 18, structured similarly to the enhanced penalty for sextortion against minors included in the House-passed version of the bill. The amendment is intended to recognize the unique harms that image-based abuse imposes on youth victims. Ultimately, we view this as a policy decision for the committee, and we support the Senate-passed version of H626. Thank you for your time and consideration. I'd be happy to answer any questions." So my biggest question for folks, should we hold off and take a 10-minute break and see if Matt Valerio gets back to us? Do we have questions for Charlie? Do we want to?
I have a question I think you can answer. So the Senate passed version of H626 includes this amendment?
Right.
Okay.
Yeah. That's how I read that. Yes.
Right.
Yeah.
That's what I thought.
Yeah. It's favorable with amendment.
I don't have questions for Charlie. It seems straightforward, but
Okay. Yeah. No, if we don't have questions for Charlie,
I
we
mean,
can just see if I can hear back from Valerio on what he wants to do. I don't think there's a problem with me sending his response around to everybody.
Just give them, if nobody's got a problem, why don't you just give them 10 minutes?
Okay, yeah, we'll do that.
I mean, that's my, I mean, if people want to go out there, I don't have, I mean, I trust that too, but
Right, right. Um. Yes, go, Nate. So Nate, can you just, I know, I don't have, Matt Lario's cell. Could you text him and see if he wants to, me to either read his email or if he wants to jump on the Zoom that you sent him?
Yep. One moment.
So I think I might have another bill coming over from the Senate that they voting out 410 with that's the recidivism definition with a fairly minor amendment from what I understand.
Back today too.
No, well, let me see. It's on third reading today, so it'll be possibly on our action calendar on Tuesday. So Tuesday afternoon, we can. Yes.
I can talk to you about it.
Do that, sure. Sure. Yeah.
Before we I guess I'm just getting caught up on this bill again, reminding myself of it. So I guess the only things are, so the sextortion language where we've got the minor, if it's someone under the age of 18, that it's going to be a felony. So we have no misdemeanor version of the crime for sextortion. Is that correct? Okay, that's on here. Yeah, so if it's someone who's over the age of 18, it's a 3-year
3-year.
felony with $3,000 fine. And if it's someone under the age of 18, it's a 10-year felony with a max $10,000 fine. And so when we sent this over to the Senate, is my memory correct that we were kind of looking at voyeurism as not as, I mean, they're both very serious, but the reason we didn't have a misdemeanor charge in there was in the sextortion was the testimony we heard and sort of the additional harm that can come from that versus the voyeurism, which is just the act of sort of taking the video or taking the photo.
Correct. So it doesn't change. So under current law, voyeurism without further dissemination is a misdemeanor,
Okay.
no matter the age of the victim. Senate heard from one of the victims in the case where one of them was a minor. And that brought up for discussion purposes, the issue of, well, if someone puts a hidden camera in a bathroom and is recording minors, they felt from a policy decision that that should be a higher penalty than if it was an adult.
Yeah. Yeah.
But it doesn't change it with regard to the dissemination. It's
It's
no
just.
matter how you disseminate, who is the victim in the case, it would be a 5-year felony.
Yeah. Okay.
You good?
Yeah, I mean, I think the only, sorry to interrupt you.
Yeah, no, go ahead.
It's just I think it's just the two minors, concern that, just that, yeah, that you would be essentially immediately hitting somebody with a felony on something like that. And maybe that is what we want to do. I just am kicking the tires on it a little bit.
So yeah, we can hear from Matt on that issue, maybe. If we can hear from him on this at all. The other thing is, we'll hear from Matt and we can postpone the straw poll until right before the floor. We just get here 5-10 minutes before floor. And so people can think about it over the weekend to make sure that we're good. I don't want to, we don't need to rush this. people really want to.
Matt is thinking that it would be best for him to come in and just join the Zoom and just say
Okay.
his thoughts himself, just in case there's any questions.
Okay, so is he
No.
gonna log on now then?
Yes, and in a moment I'm gonna coordinate with him and just make sure he has the link that I sent over and whatnot. So one moment.
All right. Okay.
So can I ask a question?
Yeah.
Sort of Ian,
Yeah.
is the concern that, or rather how, so it would be a felony handled in family court?
Yeah, and I mean, it could be in criminal court, right? It doesn't have to be in.
Is it one that
it
could
starts,
be-
it has to be, does it have to start in family court?
If they're under persons under 18,
Yeah,
it's not one of the
Yeah.
offenses that would start in criminal court.
yeah.
So it would start.
Could it be moved to criminal court?
I
don't remember.
But I don't
Think so?
think so.
Okay. So it would be confidential. Yeah,
Is like, how different, I'm just kind of curious, like how different is probation for a felony offense versus a misdemeanor offense in family court? Juvenile probation.
The records can run as far as the attorneys and sheriffs. I mean, as far as like conditions, like while waiting and then probation after, it's gonna be more about the facts and circumstances of the case.
Okay.
You know, less than it's an M or an F. The only thing I would, DCF in the risk assessment, like when they're kind of running through. I don't know how much you'd have to ask them. I can't remember now, a little too far removed from remembering the mechanics of that, how much it would impact, but it would be more around the facts of the case and then any history that the juvenile had.
Thank you. Yeah.
Yeah.
Thinking that was sort of that was my understanding, and that helps me feel comfortable with
Yeah.
this amendment.
Yeah.
For the under 17 offender or under 18.
And it seems like trying to rehabilitate and educate that person could make a difference without, having them.
Yeah.
yeah, and I'm not really, I'm just sort of walking through it myself.
Yeah.
And I think generally when I'm thinking about criminal penalties, and there's kind of a sniff test of just like, okay, if this was two 17-year-olds and someone was videotaping another in a locker room or something, and they get a felony criminal charge, and like I'm the parent of that 17-year-old, I'm just like, does that feel like the right? Yeah. But given that it would be in family court and confidential and.
Yeah, it's interesting because if you were an adult in a locker room filming a child, you probably wouldn't hesitate.
To be a felony.
Yeah.
Conviction, or a felony charge, yeah, absolutely.
So, yeah, I hear does a 17-year-old or fellow, so you get teenager really they're not gonna, most likely not gonna have the awareness of the, right,
Depends on also the particulars, right? Like it could be really intrusive and really feel like this is not good. Versus like, oh, I thought it was gonna be really funny to film so-and-so, right? So
it's still that, if you're in a place with an expectation of privacy, I don't know, it doesn't.
but remember, it's the brain
violation, it's the
development of the.
Right, and so we sort of handled that on the back end with the, family court and probation versus.
Voyeurism is intentionally, so you have to, like, it's not knowing, like, oh, someone might walk by without their clothes on.
Right, right.
I'm intentionally setting up a camera.
If I know someone's.
Right.
Right, so, Attorney General Valerio is momentarily gonna be joining us. And also talk about 19 and 20-year-olds.
Or we could talk about this amendment.
Right.
So you're all set for Tuesday.
So you don't have to come back?
Just thinking we might as well make the most of your time.
Okay, sure. I'll tell us how they're.
And I can share my screen too, to show you. Um,
And if Michelle's sharing her screen, I won't see if when Matt is jumping on. So Nate, make sure you tell me because we want to jump right to Matt. And we'll interrupt our 410 if we need to do that because I know he's got
On
other
it.
down in Rutland right now, but
He literally, pardon me. I just unmuted myself and he just got into the waiting room.
okay, so let's go back. Sorry, you're so close.
Come back, come back.
Come back in an hour.
Successfully shared your screen and everything.
You can do it right after Matt, since you're here already.
In an hour.
But we'll hear from Matt Valerio first. All right, Defender General Valerio, if you are with us, certainly join us by unmuting yourself. Maybe he hasn't connected yet. There he goes. Thank you for being available in such short notice, Matt. Appreciate it.
That's fine. I'm, I guess, commenting on the amendments that the Senate made.
Yes.
And for the record, I'm Matt Valerio. I'm Defender General. I don't have a lot to say about this. These bills regarding sort of this type of activity, I guess, can occur with people of all ages. I think that some of this sort of stupid behavior also, however, tends to arise with younger people. And, my biggest concern about these, and has been over a period of years when we first were talking about voyeurism and other things, is how it might impact younger people, 19 or 20-year-olds who are involved with 17-plus-year-olds or people who they're going to school with and the like. When they're under 18 years old and they end up being subject to a felony for a first offense when you put an age limit on being under 18. I think that in the intervening years when youthful offender has become a more robust option for the resolution of these cases, some of those concerns of mine have been mitigated, but I always have a concern when it's a first offense and it's a young person and they are not, they don't always do things in a smart way. Whether that should be a felony or not. I don't really have, and I indicated this to the chair in an email earlier, I don't have any data about how many of these cases there would be. I doubt that it would be anything significant as far as numbers. I don't know how or when these cases might come up. I get the sense that a fair number of these might arise with young people doing what young people do, being stupid things. But I'm also sure there's a fair number of full-grown adults doing stupid things too. I just think, the under 18 with involving young people and having that be potentially subject to a felony would be a bit of a concern for me. I don't, it's not the kind of thing that, it's worth making a huge deal over. I do think the youthful offender statute would solve some of that. But I wanted to bring up at least the idea, the concept that, when it's young people doing things, it's not always with with a mature mind, obviously, and having a first incident being a felony to me might be a little disproportionate. And, you know, it's obviously your policy decision to make, and then legally we'll respond to it as we need to.
Questions for Matt? No, I think that we understand the choice, I think, at this time. All right, I appreciate you being available on such short notice, Matt. In a little discussion. So where are folks with this? They need a little more time to think it through over the weekend. Are we good?
I don't mind the first offense. I mean, Matt's point seemed well.
Yeah, and I guess I'm not sure how to.
Right, we'd have to say like, if the victim and the offender are under 18 years of age, something else happens, right?
Or within 2 years, there's language like that.
Yeah, I know, I hate that. That now.
Yeah, I think the one thing with this is that I was just talking to Kim about it, like when thinking from like a charging perspective, when you've got like Barbara's point, like the facts could be lots of different things or something like this. And when there's like no room for how you charge it and it just has to be a felony, is like the only thing that's kind of sticking.
Is it a
in my-
disincentive to charge it?
I don't know. I mean, like, I could just see like something that, again, these are serious crimes, and I'm not trying to say that it's not, but just like in the level of seriousness, something where the conduct is like not as serious and like there's no room here, and you just have to charge it as a felony. It's like and I'm particularly thinking with minors or people right in that age group, just because I agree with Matt's point that just like that's probably where a lot of this could happen.
So what's the matter with the kind of, we have that elsewhere, and Matt can remind me, or help remind elsewhere where we talk about if the age is within this close to each other in the younger age. Matt, where else is that?
It's in the sexual assault statute where it's, you know, if there's otherwise consensual sexual activity and the person is within, I guess it's under 19 and over and 16 or over, or they're within a couple of years of each other. It's in the sexual assault statute, which used to be statutory, this whole so-called statutory rape. Other states basically do like a 2 or 3 year window and say if others also talk about, you know, if they happen to be schoolmates kind of thing. But the more common one is to do like a 36-month window.
Yeah, go ahead.
Matt, can you think of any examples of that framework where there is no consent?
No.
That's what I was gonna just notice is that the LNL with a child and sexual assault, in the age gap, provisions, there is otherwise consent, by both of the parties. Again, policy decision for you, but it is different here. And also that age gap means that the statute doesn't apply rather than having a different penalty, right?
Yeah, my guess is that if you don't mind if I chime
Please,
in.
go ahead. Yeah.
My guess is that a lot of these arise when like the, you know, photographs or whatever those might be consensual, but that the you know, distribution of them or threats to distribute or the like would be the non-consensual part. And it's just a little bit different than, you know, the actual physical contact kind of thing. But again, you know, it's just something to think about when you're tailoring this and as you know, was suggested, when a prosecutor really has no option to charge anything but a felony, that ends up being a concern for them, and obviously a concern for the people involved. And also, it makes it harder to resolve, to be honest.
Is there
I just-
any way to put a may in there, charge the felony, but may be a lesser charge?
Or other way around,
Right.
or misdemeanor may charge felony.
Depending on the circumstances. Right,
Can I
like,
just
Yeah, go ahead.
clarify that the dissemination penalty has not changed?
Right.
And so it is the
Right.
same, no matter the age of the victim. The change that came in the Senate is just on the viewing and recording, not the dissemination. So,
And I thought, and that was what I was trying to remember, like, I think we had discussion about kind of the distinction between those two crimes. And one of the reasons why the penalty on the dissemination and all of that is serious is because of the additional harm that comes
Right.
from that. And that's where I'm like, that's, yeah, where when we're kind of lining them up again, it's like, yeah, we're saying that they are, same in maybe a way that I don't know if I agree with, but.
We don't have to rush this through. We can think about how we can try to address it so there is an out, so that there's some more flexibility for prosecution to have a misdemeanor charge. We can do that with an amendment, a further instance of amendment, or we can ask for a committee of conference if we want to just, sit down and sort it out with them that way, or we can agree with this. But I think probably we need like over the weekend to think about it, or,
Did they discuss any of this down there? Doing this amendment?
I mean, did they discuss?
Getting into the underage stuff like.
I mean, to some extent, they didn't have as much discussion as you were having around that. They did, it was asked and answered that, like, would the circumstances that you guys are talking about, would it go to family division? But they didn't, I don't want to speak for them, but I think, they knew it would go to family division, and so they supported.
Since they didn't change it, I'm gonna guess they're probably all right with the existing law. And I'm wondering if it needs a little too much discussion right now for an amendment.
in what sense, I'm sorry, just that.
Do we have time to really hash it out and vet changing the existing law?
Is there amendment or?
No, the existing law as far as people underage go, under 18.
I guess I'm not understanding.
Maybe I'm not understanding.
No, I mean, are you worried about the amendment that we got or?
No.
Okay, all right, that's all I just don't put that. Yeah, Karen.
I feel like I could go either way on this. I think it would be helpful to understand from the Senate perspective how important it is for them to just stick with this, or if they're open to conversation, because I wouldn't want to send an amendment back to them if they're feeling crunched for time. Like, do we just keep it as is and revisit later, or do we go just to a committee of conference? I guess I would need that information in order to decide what to do with this too, because I also want things to move forward. And so if something's going to get stuck, I would rather move it.
Agreed. And I guess I'm just trying to understand how big of an issue it is for prosecution. And I'm looking to Kim and Ian, understand that part of it.
And Charlie's popped on too.
Yeah, I do see that, Charles.
Can I ask a question?
Yeah,
about
yeah.
that? And that, so, Kim, for you is, are there no other crimes that would sort of fit the facts?
That's actually what I was just kind of racing for you. So if we do want to take a little bit more time, because I'm trying to read very quickly to be like, well, maybe I can charge it this way, which is what a prosecutor would wind up doing. Is he said, if it didn't, you look for the facts fit another charge. If you didn't have the discretion between a misdemeanor and a felony.
Yeah.
And I would just say that, like, when it comes to Grafton's law, that if you force a prosecutor to kind of like search for another crime, sort of smush into this so that they can charge it as a misdemeanor, instead of just using the crime that it actually is because the penalty is not correct. I would say like, yeah.
Yeah, I'm just trying, yeah, it would just, that would impact in my decision if if the options were like, go with this or. I don't want to, if someone were to say that the existence of this crime as a first offense felony, is going to mean these don't get charged. Then that would change my feelings about it. If that's not the case, then I would say I'm probably okay with it. Just based on my understanding of the handling of delinquency cases and the long-term effects of those cases, I feel like maybe I'm missing something, but I don't see I don't see the big difference. So between charging a felony and charging a misdemeanor in family division. But I could certainly be missing something.
Well, and for the record, piping in from the side, Jim McManus, the Department of State Attorneys and Sheriffs. I mean, one thing to consider is if it's a juvenile, say 14 or 15 years old, gets charged with this, goes through family court on probation, and then has a probation violation, or has another delinquent act. There is a difference in reading, like looking, oh, you have a voyeurism felony. We're still kind of, that's still a factor.
Yep.
It's in family court and, depending on how many years, then person 17 and the third voyeurism act. Oh, no, we're definitely going 3 felonies if you were an adult. Like it is gonna factor into decision making. How much is gonna vary by prosecutor.
So it's more, yeah,
In the response.
eventually it might have a
Is this-
logistical impact, but
Right, like, is this person need residential treatment versus community treatment? Like,
right, but if they're
that's
repeating this behavior, I mean, whether it's a misdemeanor or felony, we've got a big problem, so,
100%.
yeah.
So it is hard to say how much it would impact. But I think it is the base feeling of like, there's potentially no other charge. And even though it's not supposed to be seen so much in juvenile court as a misdemeanor or felony, like
So they are.
it still is, and like, as Ian said, defense counsel's having a conversation with the parents. You need to admit to this behavior to move forward, and if this wasn't, like, you're still having those conversations, and the word felony and misdemeanor are still being mentioned, so, I mean, that is something.
So, Tom,
Yeah, if we make changes beyond the amendment, are we gonna have to talk to judiciary, state's attorneys, defender general, the network?
I don't think so. I mean, we're having a conversation now.
Right.
We would have, we would just need, I don't think the judge, we would need the judge
Right.
to be like, this is really the penalties that we're trying to sort out, and getting state's attorneys on board is as much as, and we've heard from the defender general of kind of where he probably preferred there being a misdemeanor option somehow as well.
I
But,
think,
I mean,
one thing that Karen had said that I kind of agree with, that if this was gonna push this down the road, to too much discussion and that type of thing, it may be worthwhile to take up at some point in the future.
Right. Yeah.
Next year.
Yeah, no,
Type thing.
right.
I mean,
That
it's
is a,
on the-
that is a
on the-
huge concern.
It's on the radar, and it certainly can be put in a notepad somewhere.
Yeah, that it's a big concern. It's gotta be, I don't wanna
It's a
send
big
things
concern.
back
It's not like
Senate.
a bigger discussion than quick fix, do an amendment.
no, why don't we just meet 5 minutes before the floor, just to make sure that people sorted it out. I mean, I'm all for this. I have no problem with recommending concurrence, but I want to make sure people have sit with it.
I won't be here on Tuesday, so I just want to say, on the record, I feel okay. I feel okay with this.
Yeah, I was just gonna say, how's everybody feeling?
Well, yeah, I mean, yeah, right, well, that's. Do you want more time? Do you need more time? Do we-
No, we can vote it. If I could, yeah, I think I don't want to delay the entire bill. The bill does a lot more than just this one penalty question. So yeah, I don't want to hang it up for that.
Yeah, and there's time that we can always circle back to things.
Yeah.
So, yeah, I don't have a problem with this, Karen.
Just one more process question is, I believe you were the reporter for this bill.
Alicia and Alicia was the
Oh, okay.
reporter on record, actually, so.
Okay, great.
Okay.
She'll be able to report this.
Did you want to weigh in?
She didn't report that. Yeah, she did report that section too.
Just want to make sure that she'll be ready to.
Yeah,
report.
yeah, I'll reach out to Alicia to make sure she's.
Yeah.
All right, well, it sounds like, I would take a motion to recommend that we concur with the Senate's, proposal of amendment on H 626.
So move.
Second.
All those in favor, please raise your hand. Any opposed? All right. Thanks for the discussion. I think it was important to have that discussion. We do our work here.
Yeah, I really appreciate the
So
discussion.
we're 902. No, that's really both you on this.
Right, no, but it's Michelle.
Oh, right, let's hear about 14. Since you're here.
You'll be so glad you did, because
Okay.
it's gonna be so quick.
All right. Excellent. Thanks for that. I said, thank you for kind of pushing us.
Okay, so now we're switching to. So 410, recidivism measures, criminology measures. There's one, no, this is gonna be so easy. One tiny change. So you remember that in Sec 1, and you created this new chapter and you have a new definition of recidivism. Okay, so look at that last sentence in there, starting on 19. The clock for calculating recidivism shall begin on the date an individual is released from incarceration or the date when an individual is sentenced to a non-custodial sentence, right? So it reads the clock for calculating recidivism.
Is it a clock or is it a count?
They do not like it being a clock.
Clock with months and days.
So that is the language that came from CRG is how. Right. So now they didn't like the clock
Yeah.
there.
The clock as well.
Yeah,
So in that fourth sentence, you strike out clock for calculating and afterwards say recidivism, after recidivism, you'd insert calculation, right?
I love
So I'm going to show you what that looks like. So this would now read instead the so the last sentence there on line 13, the recidivism calculation shall begin.
Okay,
That's it.
that's beautiful. Do we have to wait until we get the amendment to have a straw poll?
I'm
Probably.
not the person to ask you that.
More in the meantime.
Yeah, you never know.
Yeah.
I don't know.
They're voting it today, so maybe they make an amendment, maybe they do something.
Let's change it back to clock.
It's up in 15 minutes
Can it come to
for
us?
third
after?
reading.
No, they
They could make a special motion.
No,
They want to wait to
They
the
almost
session.
always hold it a day before they send it over, or at least that's what they do in Senate bills. I don't know if because I expected 626 not to arrive
Yeah.
us till today.
Can I run over to the Senate and like?
I think that.
Then we'll still do notice on
Would
Tuesday.
not be happy with that. All right, so thank you.
Sure.
We don't need you back in on that one, I think. We're
Thanks for having me in today.
we're adjourned.